Wow, that's a first. Everyone just suddenly was quiet. We've got a great panel coming up and a great topic that is coming up. And the paper is how the EU's Sustainability Due Diligence Directive could reshape corporate America. Not will, but could. And Professor Luca Enriques, who we all know from Bocconi University, is going to be taking the lead on telling us about this paper, which is co-authored with Roy Shapira and with Matteo Gatti. And I think this is a fantastic paper to finish the day and to have a panel discussion of, because I think it brings up a lot of the themes that we've been discussing during the course of, you know, what's been a fantastic day. ESG, is it dead? Colin Mayer told us, you know, a couple of weeks ago, it's dead, but it's certainly alive and well in relation to executive pay. Legal transplantation, whether the US is an outlier, and also the tension between shareholder and stakeholder-centred models playing out at a transnational level. So I'm going to hand over to Luca at this point, and then I'll introduce our panellists and we'll get the panel going.
Great. Thank you so much. It's an honor and a privilege to be here today and present this work joint, as Jennifer said, with Matteo Gatti and Roy Shapira, who will jump in and correct me whenever I say something wrong or imprecise. And so we are now moving from carrots to sticks. So we were talking about ESG compensation metrics. Now it's about how you can mandate virtuous behavior through penalties, sanctions, and so on. And what happened is that the European Union introduced a very ambitious piece of legislation. Note that this was posted on SSRN on the 6th of January, so before January 20, and when all this still had made some sense. And we, so it also used to be how the directive will reshape corporate America. It already had become could on the 6th of January, but now we might have to play more with those verbs. And so the motivation is that, as I said, this is one of the most ambitious pieces of legislation promulgated so far on ESG, and it imposes onerous due diligence requirements on firms which are either from the EU or which have a turnover of above 450 million euro within the EU. So all large firms throughout the world will be subject to these obligations, which are about risk management. Ultimately, it's about having in place procedures, appropriate measures to prevent harm to human rights, which means also labor rights, and in the environment. So the legislation, of course, has the best intentions, but our motivation was to see how it would work with US companies, because they have a strong presence, of course, in Europe. They cannot just decide from one day to the next not to sell any more their services or goods in Europe. But they also have a very different industrial relations model, and these rules are also about industrial relations. They have a different set, perhaps crumbling set of environmental regulations, and a very different litigation-heavy legal environment. So I will go down this list of topics very quickly, because we want this to be a lively discussion. So first of all, for those among you who are not familiar with the directive, large companies, whether from the EU or from other countries, but with a strong presence in the EU, have to set up procedures within their organization to identify, prevent, mitigate, and account for the adverse effects that they may create or that they do create on human rights and the environment. So these checks have to be extended to a company's subsidiaries, but also to business partners. So everyone in the value chain has to be subject of due diligence on the part of the cover company. So even if it's a small firm, and this small firm deals with a European company covered by the directive, indirectly the smaller firm will have to make sure that they are not doing things that violate human rights or the environment. Of course, this is only about appropriate measures. It's not an obligation never to do harm, but it's still, when something like this becomes a legal obligation, that's very relevant. And you may all know that the OECD had already issued guidelines on this very same topic, but there was no enforcement instrument. It was voluntary adoption of these rules, and clearly it's not the same thing whether you voluntarily adopt them and whether, in fact, you are required to put in place those things, because there's an issue of hindsight bias, and the sanctions are really can really be big in terms of monetary sanctions, but also you can be excluded from contracts with governments if you violate these rules. So that's quite something. And while and something important is that during the legislation process, a provision on director liability was left out finally. So national law rules apply on directors of liability, but as I said, there is a liability for the company itself. It's uncertain what the impact will be of these rules without liability for directors, even though traditionally there has been little private enforcement of director duties in Europe, other than in the US. In the US, you have care mark. So it's a standard, a duty that directors have in Delaware companies to oversee their organization and make sure that it doesn't violate legal obligations. To meet these oversight duties, directors must implement a system that monitors information on important risks and reports back to the board, respond when the system generates red flags, so imminent, relevant, visible risks, and the companies or directors have a duty not to have a business plan that is predicated on profiting from violating the law. Historically, Caremark wasn't that relevant in that being held liable according to Caremark was highly unlikely, but that changed dramatically in 2019 with the Martian decision. So now courts are more willing to scrutinize director compliance efforts, and the absence of board involvement in the oversight of some core risks can lead to breach of duties. And that has been made easier also given the very generous rules on inspections rights for shareholders that allow them to obtain company documents, including emails, where oftentimes directors may be candid about what was not going on or what they knew, making it easier for these suits to pass the demand phase and so proceed to trial, which meant that they would be settled and settled for higher amounts. So oversight duties have become relevant, very relevant in the US. And, but there has been very little action in the area of ESG or CSR matters. So there haven't been cases that can clearly be categorized as about the environment or human rights. So what we focus on in the paper is how the Caremark CS 3D cocktail can taste. And this is the contribution to my presentation by Matteo Gatti, who gave me the Manhattan as the cocktail that I should be on the slide. So thank you, Matteo. So there is with CRD, the combination of the two, we have an expansion of oversight duties, arguably. And so the there is a higher chance basically that sustainability-related risks will be detected because of the presence of these obligations, and so there will be more red flags and for the boards to take into account. That's our prediction, and that will also be because while today sustainability was a nice to have, or actually until the 19th of January was a nice to have. Now it's not even that. But if the directive comes into force for US companies, then it will be something for the compliance departments who will have a duty to support the board in making sure that these rules are not violated. And so, how many minutes do I have, do you think?
I was relying on you, but I don't know, 5, 3 to 5?
I don't have appropriate procedures in place. For, sorry about that. So well, this slide tells you how the directive may lead these matters to come to the foreground in particular circumstances. So if the business model relies on public procurement, of course, that's something to consider. The issues in the directive may be something the company discloses stuff about. So it may be like in the McDonald's case. McDonald's said it was great with its employees. There was a favorable working environment, and then there was this case of sexual harassment and so on. And that was because of the disclosures of the company that led the court to be quite harsh on the directors. There might be more cases in which these harms become salient because there will be a regulator in charge of sanctioning companies, and there might be more warnings or red flags that flow up to the board. So to conclude, there might be more enforcement in the US. Actually, what we experience with this, we might experience with these rules is that there will be a sort of super Brussels effect, in the sense that you know that the Brussels effect is the imposition of European rules on non-European companies for their business in Europe, and companies may decide whether to have two sets of product characteristics, one compliant with the EU rules and one not, and sometimes they decide to have the same rules for their product. Here it's even more intrusive because you cannot differentiate your risk management procedures. It has to be one set of procedures, and therefore that will be the same kind of risk management that you will apply across the globe. So the outcome of all this might be that US companies, with the combination of the directive and Caremark, may face a regulatory environment that is more, that makes them take care of these issues more than European companies, because in Europe, private corporate law enforcement is not much of an issue. And so in other words, and here I will stop. I have a few slides with some visual dad jokes for Eric, but I will go through them very quickly because I want to leave more space to the discussion. So the idea is that the cocktail may be watered down, in fact, also in part because of these concerns for US companies. So that may anger this guy. And in fact, a senator already put out a bill that will prohibit enforcement of Caremark duties violation if a US company from an essential sector, which includes all the big tech companies, not incidentally, will face sanctions in Europe. So does that mean that we will face crumbling also of the CS3D enforcement in the US. Who knows? But maybe not. And then there is an attack against the ESG regulation in Europe because many say that too much has been done, and we've been the only one to go so much down the road of ESG legislation that anger, quote unquote, and that's how much anger Mario Draghi can express, of course, but Mario Draghi had a report in which said that this should change, and so there's an omnibus proposal in Parliament currently that will water down a little bit the CS3D, but still we argue that it will have a high impact. And finally, Delaware also is watering down its own environment plaintiffs with the new rules on inspection rights, and we also argue that that may not be the end of the story. So these are my conclusions, just a summary, so I will sit and thank you for your attention.
Thanks so much, Luca. Okay, so we're going to have a panel discussion now. I'm going to throw a few questions to our panellists, but we want you to ask questions as well. So please identify if you want to ask questions, and if I don't know you, I'll try and remember you, but put your hand up later to make sure I don't forget you. I hope we have enough microphones, given that we've all got 4 here, to go around the audience, if we can get those prepared. But let me introduce you to our panellists. So we've got Phil Bartram to my left. Phil is a partner at Travers Smith in London, and Phil advises large US-listed issuers with operations in Europe. And then to the left of Phil, we have Alessandro Di Nicola, who is a partner at BonelliErede in Milan. And Alessandro assists companies in aligning their compliance efforts with EU rules and national requirements. So I just would like to ask you both, what are you hearing on the ground from companies that you are advising about the developments that Luca's just talked about and about CS3D itself? Phil?
There's lots of great lines in the paper, but one is that one of the reasons why there'll be a big effect in the US, apart from a more litigious environment and more aggressive discovery, is that US law firms are good at sending panic-inducing memos. But despite me sending panic-inducing memos, I can't really get my clients properly to engage with this yet. To be perfectly honest, the Corporate Sustainability Reporting Directive was first into the hopper to be digested, and it was being digested and thought about significantly with the formation of teams outside the sustainability team, some in compliance, but also a big role for the CFO, for example. It was being taken really seriously. Big projects on the way. But then a number of those US and global organisations have concluded they're out of CSRD, or presumptively out, as a result of the proposed changes to the omnibus regulation. So they've dumped that, and as a result it's very difficult to get them to pick up their tools to focus on CS3D, which is the next one to come, because that will apply at the earliest from July 28, more likely for some of them from July 29. And frankly, they're all just going to wait and see to what extent that ice cube in the cocktail melts and waters it down. But I think that the impact on directors personally is a really interesting angle and maybe a reason for them to refocus.
Yeah. Alessandro?
Well, Italian companies were quite ready to adapt to the CSRD. So the reporting directive was taken with due anticipation, and so I didn't notice any particular effect on the internal working of the companies. And Italian companies, large companies, are quite accustomed to this intrusive compliance. We have a law which is now famous in Italy, which is Law 231, which is more or less like the Bribery Act, or here in Britain, or the FCPA, with the difference that it covers any kind of crime you can think of. And I mean, it entails a lot of compliance efforts. So in the mind of Italian CEOs, CFOs, compliance officers, CS 3D is just another piece of compliance which is going to be added, and with the typical optimism or blindness of Italians, they think that CS 3D is dead on arrival. I mean,
really?
Okay, omnibus. They are accustomed to the Italian legislation process. So, as when you have sort of, let's say, delay, prorogation, this means, in Italy we have a saying which says nothing is more eternal than what it is provisional in Italy. So they think that, I mean, the CS 3D is, I mean, a long way to come. So they are relaxed.
Well,
I don't say that they are consciously relaxed, but they are relaxed.
They're Italian. Now, when we had some email correspondence about this, because we had big time challenges having a Zoom with me in Australia, but I did gather you are not a fan of this proposal, and I just wondered if you could say something about why you were not a fan, because that took me
Well, I
back.
think that the Brussels effect, I mean, the only effect that the Brussels effect has is the percentage of the European GDP on the world GDP, which is going down like that. So I wonder why the rest of the world should abide by the rules imposed by a bloc which has a dwindling influence and economic strength. So it would be really something unprecedented in human history. So someone who is becoming weaker and weaker, which imposes its rules to someone else who's becoming stronger and stronger. Moreover, the Brussels effect has also the problem that it is not clear what is the aim. What does the European Union want? They want to become the moral beacon of the world, which is, okay, an aspiration. Or they want, as they brilliantly wrote in the paper, just have a distributional effect, moving wealth from the global north to the global south, which would be incredible because it would be the first piece of legislation intended to damage the country of origin or the bloc. I mean, they enact a piece of legislation with the aim to put in this case, not the country, but the bloc of countries of origin in a worse situation than before. So it is not clear. So let's assume that they want to become the moral beacon of the world. Then, of course, you always have the unintended consequences, as, I mean, the Scottish Enlightenment has taught us. There is no literature on the economic impact of the Brussels effect. There are scattered pieces of research. For Germany, for instance, you quoted them, I think, in your paper. Similar legislation had the effect of damaging the textile industry in Bangladesh. The decarbonization rules, European decarbonization rules have the effect of damaging the weaker steel makers in India. So at the end of the day, among the poor, they damage the poorest of the poor. So the small companies in India or Bangladesh. So I mean, it is too vague. It is too vague. You just the reference of the CS 3D, and when I stop, there is a reference on 16 international treaties and conventions. Oh, wow. Put these 16 international treaties and conventions in the hands of an Italian judge, and
So be careful what you wish for, you know,
Exactly.
in regulation. And we're in
It's going
England,
to be
so, you know,
funny.
the home of the Bubble Act. So, you know, we've got good evidence of be careful what you wish for. I want to go to Phil to ask, and then I'm going to go Paul's asked a question. So all of you, if you want to ask a question, just get in the queue. Thanks, Jeff. So, Phil, if I can just ask you the kind of the political machinations behind EU rulemaking. So in the Draghi report, there is this image that the EU is, you know, very much united in the pursuit of inclusive economic growth, and they're going to focus on sustainable competitiveness, economic security, open strategic autonomy and fair competition. Is this a reasonable assessment of Europe? I mean, this morning I was having a chat at breakfast, and Tobias said, you know, this image of Europe as, you know, strong and united, it's got a lot of fragility there. So, you know, what's your view of how these rules are made? And if they are going to be global standards, do they get watered down right at the beginning because it's just so hard to get the various parties to agree on anything?
Sure. Just to set the context, I have a slightly different view from Alessandro on the policy here, in the sense that I think that there is something important and morally right about regulating chains of operations for EU companies, and if you accept that thesis, then there is a competitive dynamic question. So if it's the case that an EU company makes FDI into the US to prop up manufacturing businesses, then that subsidiary is subject to these obligations, and so I think there is something about a level playing field argument once you accept that value chain liability is appropriate, and I think the Brussels effect idea. After all, we're sat here in Imperial, in a country that long since lost its empire, but still purports to export some legal standards around the world. But I think that provided that the measures are proportionate, then I think there's a case for export. And I think the problem with this legislation is that it was disproportionate. In particular, the mandatory climate transition plan obligation, which is proposed to be watered down a little bit, so that instead of adopt and implement, it will say adopt and describe your implementing actions, so a sort of comply or explain process. That's one potential important watering down. And second, more proportionate in the sense that the value chain due diligence obligation in the Commission's proposal is to look at tier one suppliers only, those most proximate to the company. But I think coming from the French and the Germans, there are suggestions that it should be more of a funnel where you do a impact assessment first and then only seek to mitigate the risks where they are the most important ones. And I think that's probably the direction in which it's heading, which I think will make the Brussels effect dynamic a bit better. The politics is that we're speculating at the moment on the basis of proposals for amendment from the European Commission. The Commission is a machine for making law. That's what it does. And the Draghi report has been influential, and the commissioners have spoken supportively of it. But my sense is that, as ever, what the Commission is mainly interested in is harmonising things across the EU, making them all the same, as opposed to necessarily making them better for economic output. But I think that there is a big recognition in Germany and in France and in some of the other big member states that they really have got to do something to address competitiveness. And within the Council, it's they who will hold the pen on where these amendments go.
So let's have a couple of questions from the audience. If you can just say who you would like to address the question to. Paul Davies, then Jeff, then Colin, and then Dan. Or were you always there, Dan, and I just missed you? Yeah. So Paul first.
Okay, yeah. Thanks so much. Look, since I'm a lawyer, and this is a panel of lawyers, I'd like to propose a hypothetical for you to consider, which is designed to tease out exactly what the scope of the CS3D actually is. So suppose we've got a US headquartered multinational which sells some products in the EU, but it also has some products which it doesn't sell in the EU, but also sells in the rest of the world. So the question is, does the directive apply to the supply chains of the products which the company sells not in the EU, or do they apply to the supply chains of all the products that it produces? I've had a variety of different answers to this question from...
Phil's going to give the correct answer.
Yeah, I could see him building up to it, so let me stop and wait for it. But just to say that obviously if the answer is it does apply, then that's quite a question of extraterritorial impact. If it doesn't apply, then it promotes partitioning of markets.
Well, I think you've uncovered an interesting threshold question. I know we've got lots of accountants in the room, but there is a question about extraterritorial scope and how it works. It's expressed to apply to a non-EU company where that company does 450 million of has 450 million of EU-derived turnover. I challenge anybody to go and find a set of US company accounts that call out EU-derived turnover, so that there is an interesting scoping question there. If you're just selling goods directly into the EU, perhaps that's obvious, but I think there are other business models that are more challenging. I think there's also questions around whether you can avoid having EU-derived turnover simply by selling it to somewhere nearby and secondary imports, for example. But once you're caught, the directive is clear that it applies to the whole of the enterprise, including all of its parents and subsidiaries, in respect of its operations generally, including those businesses that don't touch the EU, which is deliberate, massive extraterritorial reach.
Yeah, I want to talk about, pushback against that later, but let's get another question from Jeff.
So this is, again, a sort of a lawyer's question, at least US lawyers. Caremark provides recovery or a monetary sanction against loss incurred by the firm in respect of a violation of law. So in the story here, I'm not hearing how the US firm is going to suffer damage from the violation of the directive in most cases. And so therefore, the connection to, the whole US machinery that Luca and authors have described might not have fuel to get going. So it seems that the only the monetary sanction that you described was the loss of procurement chances. And if the firm doesn't ordinarily sell to a government, or maybe stop selling to a government in any event, then what's going to be the loss that the firm suffers? It might be bad PR, but that's unless you can really show there's a monetary harm, then so what, right?
So Jeff, I think this comes up in the paper, and I think Roy's going to answer this one.
Luca is externalizing the harm to me.
Yeah.
So Jeff, so it's not just exclusion from public procurement. So you could get sanctioned by the regulator, or you could get, so say there's a certain environmental trauma in one of your, again, throughout your supply chain, and you're getting a tort action or whatever, okay? So as long as you get hit, and granted, it's not completely obvious that it will happen, but as long as there's some corporate trauma, then if I'm an entrepreneurial plaintiff lawyer, especially now after SB 21, this might be my best chance of gaining success. Why? Because I will have a lot of information. So even if it's, so either there's a sanction by the regulator, or exclusion for public procurement, or some private tort litigation against me. And now there's a lot of information because there have been dedicated regulators in each EU member state collecting information or monitoring my oversight or monitoring my due diligence. So if I'm an entrepreneurial plaintiff lawyer, I will come to court and I will say, listen, I have this, the European dedicated regulator in Austria or whatever sent you warnings 2 years ago about how your supplier treats the environment or how that supplier treats human rights. And that's a red flag. How come you didn't do anything about it? So it's true that I guess, and I think we write it also in the paper in the last section, the one condition would be, did they suffer a trauma? But they could suffer a trauma from a separate legal action. They could suffer a trauma from monetary sanction by the regulator. But once they do, then as a plaintiff lawyer, I have all the information I need, even before Section 220, because I have all the information that you submitted to the European regulators.
Well,
so this is
trauma,
kind of fascinating.
Let me just
Yeah.
follow up. I mean,
You want
trauma
damages.
is a, you know,
Yeah.
a therapist's idea, but it's not pecuniary harm. And insofar as a firm in the supply chain suffered, there was a tort issue and the firm in the supply chain sues the parent, well, that cause of action exists or doesn't exist apart from the directive, right? The directive doesn't give additional rights to the party in the supply chain to sue a U.S. issuer. So that doesn't particularly add to the story. And if the trauma is not a pecuniary one, or is remotely a pecuniary one, then, you know, again, it seems to me that the causal link between a pecuniary harm to the firm and the potential risk management oversight of the board is going to be hard to make out a strong claim.
Right, so you're right, as long as there are pecuniary damages, all right, our point is that the directives make it easier to link the directors to that harm. Because
Phil
they will
wants
be-
to come on,
I'm
in
sorry.
on that as well, because
Yeah.
it's the backdoor method.
Some features of the directive which are, your question is very apposite, I think, but some of the features of the directive that are potentially relevant here are the fact that it initially included fines from each relevant EU member state regulator as a percentage of global turnover, so potentially significant numbers, were they to bring enforcement action. Second, that there was going to be a whole framework for direct civil liability claims founded on breach of the directive by any actor, or not. It wouldn't have had to have come through a regulator. An affected person could sue directly under the directive. Both of those things are up for grabs in the renegotiation under Omnibus and may be watered down. But what there will certainly be is a follow-on damages provision to the extent that an EU regulator enforces. But I think that's a really important question, and it does depend on whether those regulators are toothsome and whether they pursue it. One has to be a bit sceptical about that. We don't even know who we're talking about here. Trade ministries may be in individual member states, and then they've got to go first and stick their heads above the parapet in a context of tariff wars, for example. But if they were to do it, then and if it were meaningful, then I think it's the indirect effect is the thing that the authors are bringing out, which I think is a valid point.
It's interesting, though, that I think you bring out, you know, that this, you know, disgorging disclosure of information in the European context, because, you know, 20 years ago it was companies like Siemens got caught because of greater disclosure in the US context, and, you know, they said, let's, you know, delist from the New York Stock Exchange and go back and just be in Europe. So this is kind of, you know, the worm has turned. Alessandro?
Yeah, just as an example. What happened in Italy a few months ago, and Luca was, included in this litigation in a way, not as a defendant. There was a very famous string of cases, very famous also for the general public, because the defendants were companies like Armani, Dior, so everyone was reading it in the newspapers. What it happened was that the public prosecutor indicted the three companies and relying on an anti-mafia law, very creative. The prosecutor appointed a judicial administrator to manage a part of the business of these three fashion houses. So you can imagine what an Italian judge can do with CS3D, appoint an administrator relying on an anti-mafia law. Because the three fashion houses didn't put in place a system of an adequate system of controls for their supply chain. So, in other words, the prosecutor said that indirectly, not the supplier, but the subcontractor was not respecting the rights of the employees and health and safety and so on and so forth. And the three companies were responsible, exactly like in the CS 3D. Now, with the omnibus proposal, it is only the direct business partners. But in Italy, we are already forward, even the indirect business partners. And what it happened, apart from all the damage to the companies, which have not been condemned yet, so the case is still in course. You can imagine for the reputation what happened. The antitrust authority, which in Italy has also competence for consumers' protection, started a case against these companies, relying on more or less what the SEC would do in the US for misrepresentation, because all these companies on their statement of intentions and so on said that they support sustainability, fair conditions of labor and so on, and human rights. So this was willful misconduct behavior, just giving a false representations to consumers, and now the antitrust has started this case, which can have as a consequence a fine, so money. So it is not even necessary to wait for the authorities that are going to be appointed thanks to the CS 3D, because every country already has some authorities that can take this role. This is the reason why I think that the CS 3D is dangerous. It is dangerous even because now here everyone is a jurist or a lawyer, but if there were someone running a venture capital fund, there is a new opportunity for the litigation industry, because if you just have a good software which detects any decision in any country of the world, anywhere, from Indonesia to Thailand, which condemns a company not to have respected environmental regulations or labor regulations, and it happens that this company is a supplier, a distributor, a business partner, whatever, of a European company, then you can sue them.
May I just briefly expand on that? Because I think that's really important. I think the implications for asset managers of this are potentially very significant, venture capital, private equity. So let's say something goes wrong in the value chain that comes back to the private equity portfolio company. There may be an issue within the portfolio company, but to the extent that that's controlled by a financial investor from the US, a fund from the US, then they may be within the group, potentially, depending on how the fund is established, and that might come back to bite them. And I agree with you that, and I think this was the point you're making, that the claims can come anyway. So there's a line of cases in the English courts, for example, Vedanta, Okparbi, Client Earth and Shell, for example, which are founded on nothing to do with statute. They're simply tortious theories that a UK-listed parent has accepted responsibility for something that's gone wrong in its subsidiary or in its operations, say, in Africa, and that's attributed to the parent because of an assumption and of an acceptance of responsibility. Those have so far only gone through procedural steps and have been rejected so far, but they're coming, and I think they will come after asset managers next, because those people have deep pockets in relation to the same relationships. But CS3D could make those claims, I agree with this, could make those claims more likely to be brought because there is more information that could support them, and also possibly more likely to succeed because it's easier to establish that the top entity has accepted responsibility for what's gone on lower down because there's a statute that positively requires it to go and look and to put systems in place. So I think it does, well, those claims are there, but I think this does notch them up.
So we've got 15 minutes and 5 questions in the queue. So let's take 2 at a time. Colin first and then Dan. Colin.
I'd just like to introduce the ISSB into this discussion because there is some suggestion that to advance the ISSB agenda that the EU might well adopt it in the first instance. And that might then provide a pathway by which one could move steadily in the direction of initially the EU adopting a single materiality reporting, which then broadens into a double materiality before moving any further along the chain. So I'd just like to hear your views as to how ISSB might influence
Before you
it.
give them, let's hear Dan's question, and then you can answer both. Yeah.
So this is sort of related, I guess, 2 points. One is, I wonder if Paul's been advising Chinese companies, because one strategy I heard that from lawyers in China was that they were going to sort of bifurcate the supply chains to have sort of green zones, which would be EU zones compliant, and then other zones. So it's exactly what you were suggesting. But the second point actually relates exactly to Colin's point, that I was shocked. I think actually I have a paper with Rosa Nergohayev called Corporate Purpose Beyond Borders, A Key to Saving the Planet or Colonialism Repackaged. And I think you guys actually maybe cite it in your paper. But this was written before, it was published now getting close to a year ago. And at that time in China, so there's only 3 economies big enough in the world to sort of have a Brussels effect, right? It's the EU, the US, and China. China, through Belt and Road, had little incentive to sort of externalize its view. But quite fascinating, when I was, two weeks ago when I was in China, and I was speaking to people about ISSB, they said that there's a lot of talk about the Chinese maybe accepting double materiality now. And why would they do that? Because if they're frozen out of the United States, all of a sudden what was said about the EU's share of the global economy becomes much bigger, because if the US is out of the game and China has as its major big option ASEAN in the EU, then this could be a wedge driven between the rest of the world and the United States if China gets on board with double materiality. And so I was quite shocked to hear that they were mooting this idea of double materiality, and it makes perfect sense also from a geopolitical perspective when they're leading with EVs, solar panels, and all of these green technologies to actually make this shift towards double materiality. So when we wrote that paper, I thought there's no chance, but this is the Trump effect on maybe the Beijing-Brussels effect in a weird sort of way, driving this idea of double materiality, which I thought was dead in the water and is now getting some life because of what's happening with Trump.
What do our panelists say?
Well, ISSB is getting traction. I think Australia is on the road to adopting it. The UK is indicated it plans to adopt it, although we wait for formal announcement of that because I think there's a lot of nerves. But that is avowedly only disclosure, and it's only disclosure on a single materiality standard. And you might get a coalition of the willing, but up till now, the big obstacle has been that the US will not engage with a global institutional standards setter because it will say, we want control of that, even though ISSB is big chunks of it. Lots of them are American people and lots of them are based in America. So I think that it's facing real challenges even now. But the key point is that CS3D is way more than disclosure. It's a positive normative set of rules. It contains disclosure within it, extra disclosure, so that if you have the harms that you've identified, those must in addition be disclosed beyond ISSB or CSRD, but it's extra.
But if I may add something, so adopting the ISSB standards for the EU would be a step back. So it won't.
But I think the idea is they could adopt the ISSB and go as far as they want in terms of the double materiality.
Well, they already have
They
double
sort of, the
materiality.
SRSs
so-
are aligned to ISSB very closely.
Okay, we have 3 questions. Holger, then Ernest. Oh, no, we've got 5. That's bad. And then Marius Sunter, and then I'll add Ellen and... Yeah.
I'll try to be quick, even though it's a deep question, primarily to Luca, but depending on his answer, also to his 2 co-panelists. What do you mean by reshaping corporate America? I mean, there's 2 ways I can hear you. One is just, this directive is big, there's lots of money at stake and whatever, so US companies will have to comply for their own sake and for their director's sake, otherwise they might be liable on the care mark. Okay, of that, we can quibble about the details, but that's easy for me to understand. I think I heard you occasionally say something else, or maybe I read your paper in a different way, that there's something deeper going on here that is reshaping corporate governance in the United States to be not shareholder-centric or whatever. And there my reaction is, why? I mean, isn't that just regulation? We have regulation everywhere. We had regulation before. We have it now. All this is doing is introducing a new form of tort action and regulatory obligation. You know, it's actually a soft tort action because not strict liability is a form of negligence liability, even less than that. And so I would just wonder how I should, which one of those 2 versions you mean, or maybe a third one, and then depending on that, maybe your co-panelists have something to say also.
That may be a Luca or a Roy, but let's Ernest.
Yeah, so do you think there's a possibility that shareholders in red states in the US will bring a lawsuit not on the basis of care mark, but against the directors for breach of fiduciary duties to maximize shareholder value if they comply with the CSDDD? Because investors and attorney generals in certain red states has actually sued, right, the asset managers for breach of investors' fiduciary duty. So that's the flip side. So that could be I wonder that could be a possible irony.
Yeah. The overhang of the US. And Marius Sunter, and then we'll go to answer those, and then if we've got time, we'll go to the last 2. Marius Sunter.
I have a very specific question for Luca. No, for Luca, sorry, for Alessandro. And the question is, what you said about the antitrust, for me, was the antitrust pursuing a case of greenwashing. I'm wondering on what basis is very interesting for a financial economist.
Okay, so let's start with Holger. What does it mean, this transformation?
Ellen, you mentioned...
No, we're going to do 3 answers to the 3 questions we've had, and then I'll go to Ellen and then to Anat. Yeah, Anat. So who wants to answer Holger's question about the transformation of American corporate law? Is that a Roy or a Luca question?
No, we can't always use the jolly here. So, and of course, it's not. It's a tricky question because the truth is that you have to make bold claims when you want to sell this stuff to JDs, and it worked very well in our case. Target, we reach our goal by you being so emphatic about the effect of these rules. So I would say that the substance is closer to how you put it, which is it would have been an incremental step in the direction of making board more aware of ES issues in US companies. How transformational that would have been, again, in a pre-Trump world can be debated, but and Roy could answer this better, but the effect of care mark duties post-2019, as far as I understand, has been significant to the way boards address issues that have an implication in terms of oversight at US companies. Again, as I hinted at, that did not include CSR issues. It wasn't something that would come up particularly significant. Of course, environment is somewhat different because there can be tort liability. There are, but human rights, for example, that would be less something that it would be on their radars. That would be my perhaps unsatisfactory answer to Holger, but I gave the sincere one first. And I think the answer to your question, either I didn't get it or it's very easy, because these are Delaware companies, and it doesn't matter where you come from, whether you are a shareholder from a red state or not, you can go before a court, and the court will decide the case on the basis of business judgment. No, it's a business judgment by the directors, whether they decide to comply with these rules or whether they decide to ignore them. I don't know. So if they decide to ignore them, of course there's karma, but that wouldn't be the claim of the shareholders you have in mind. The claim would be that they shouldn't have gone in the direction of complying with these rules, and I don't think that would go anywhere, although I'm not the Delaware expert in.
Well, there have been some actions on that basis.
But that was state prosecutors against.
In Florida, in Texas.
It's different.
Yeah. And I think that so far they've been a little bit wary where you can point to a positive statutory obligation. For example, the DEI gender pay gap disclosure reporting that's coming from the EU. The red state attorneys general are not going after companies for compliance with that, because it's a hard case to make out.
Yeah, Mario Sunta's question to Alessandro.
I'm not completely sure what kind of answer would you like to have. So, are you asking why the antitrust authority took the pain of intervening, or what?
So, I would have thought that the CONSOB would have gone after the company for the wrong claim,
okay. Yeah,
not
so
the antitrust
the question
authority.
is why the antitrust
so I want
took
to
the
know
pain.
what is
yes,
the...
Yes, okay, because it is a different set of laws. CONSOB could have intervened if the fashion houses were listed at the Italian Stock Exchange, which they were not.
Okay.
While the antitrust authority intervened because they have competence for consumers law, and they alleged that this was basically misrepresentation or false representation.
Greenwashing.
Greenwashing, in this case, labor washing. Greenwashing or labor washing about their labor practices and so on. This is the reason why the antitrust intervened.
Okay, so we want to hear the last two questions, whether we've got time for an answer. That only Elaine can know that, but Ellen, we can just a couple of minutes. Yeah, Ellen and then Anat.
Thanks. So with a lot of emphasis on the could there, do you have a sense of the relative scale of potential fines or other penalties on the EU side, or of the settlement size in the US, since that would feed into how upset shareholders could get? And then any comments you might have on likelihood of enforcement as well.
Probably you, Luca.
So now there is a... so the sanctions are to be defined by member states, and now there is a provision that says that member state cannot provide a maximum sanction lower than X% of turnover, where X is 2 or 3? 5. Sorry, but yeah, so 5% of turnover, global turnover. This is something that the Omnibus Directive would like to take out of the table. So we don't know.
I think that the Omnibus Directive will take out the minimum fine, but I think I read it 1 month ago, but I think that it leaves the it leaves the roof at 5%. So there is the possibility for the member states to provide for a 5% fine.
Or higher, actually. Yeah.
Oh, yeah, of course, yes, gold plate, higher and higher, of course.
But it's also really quite complicated how it applies to an EU group, which presumptively will have operations across member states, and who the relevant enforcement authority is in those circumstances. That's a total mess under CSRD and under this as well.
Yes, you risk to have 10 authorities, each of them suing the same company or the same group in their jurisdictions. Yes, it's horrible.
Yeah, well, I was just going to bring up, that ultimately, very much following up on that, the actual enforcement of the rule is where it's at. The shareholder governance part of it is, kind of tangential in the end. Either the company, is able to, satisfy shareholders or not, and it's partly how the law enforcement would work on the given law, which I gather from what you're saying is complicated and could lead to under or over enforcement for all the usual reasons of corporate enforcement. So I was just going to bring up the complexity of enforcement as sort of ultimately the key question. And the shareholders is really, the care mark is not where the main thing. And I see Roy nodding, so it's good.
Yeah, but you've got a good point. But if the companies could face all manner of regulatory schemes that it could get fined for, I think the point in the paper, which I still think has some relevance, is that it causes US senior management to sit up and think, well, maybe I've got one of these listed structures where I've got my own personal company above it, and I can actually not worry because I've got 2 layers of limited liability insulating me from anything here.
Not just that, the insurance, which is also applies to Caremark. So let's not forget that the directors themselves, which you keep saying are, going to be so scared, are insured.
That's true.
Mm.
So I told our commentators that it was a lively audience and to expect it to be fast and furious. Thank you for, not proving me wrong. If we can thank us.
Thank you.
Claudia, you're going to finish up now, I think. So we'll all stay where we are.
Okay, thank you. Okay, so just a few words. So thanks, everyone, all the presenters, all the discussants, all the panel members. It was an impressive set of papers, so in very lively discussion. Just a few things to announce. So dinner is going to be at 5 in the Smith Center, which is just around the corner at the Science Museum. We can gather perhaps at 5 at the reception of Imperial and all go together, or you can go just directly there as you prefer. But we can, perhaps the easiest way is just for us to meet at the entrance of the Imperial by the Queen Victoria statue or something, and we can all go together. So thanks so much for the great day.